Good afternoon, people. This is now Thursday afternoon. We are busy with principles of property law today, and we are only going to discuss the law on contracts today. This is now the last part of the course. As you hopefully have seen, I have summarized the original chapter for you in about, say, around about 25 pages. And yeah, really people, you will now just have to study that. No, I have already set the papers, and the law of contracts is quite a substantial. No, I thought it would be about 30% of the paper, but it's more towards 45% of the paper. No, so make sure that you understand the law of contracts. No, as I have explained to you previously with regards to being a valuer, everything in terms of value of property starts with a valid lease agreement. No. So it is to me very important that you understand the underlying and basic principles of what constitutes a valid lease agreement. Then, yeah, we're just going to discuss a little bit about the upcoming exams. I've tried the format of the exams to be very similar to what you will have experienced during the year with your little revision test. Obviously, the format will be a little bit different due to you now writing it physically, but I've also have been kind to myself, you know, to make marking easier at the end of the day. So it will be really short, sort of 1A, 2C, that kind of thing. I've tried to structure the paper like that, all the answers are more or less there. You just need to pick it out or pick out a certain word. That kind of scenario will also be there. And then obviously, due to it being your final paper, there must be some essay questions in the paper as well. But that is limited, I would say, to 5 marks at the most. Okay. And it would be things that we have deemed or I've indicated to you that is quite important. No, things like the definition of market value, no, or your highest and best use with that potential that goes with your definition. Or if we're doing law of contracts today, no, that sort of definition of what makes for a valid contract. No. So those kind of things. I've also concentrated on servitudes. I told you before, and in my scope, that we will cover servitudes. In the exam, I have sort of went and rechecked my paper. There's quite a number of servitude questions in the paper. Again, because that is the one part, small part of the law that you will be confronted with every time you do a valuation. If you read that the title deed, there will be a servitude mentioned somewhere, even if it's just your municipal servitudes that may not have any effect on your valuation. You still need to get that SG diagram, you need to read that title deed, and you have to inform your reader of either there's no influence, or he must perhaps take it up, he must perhaps consult a lawyer to have this whole problem, you know, advise him on that. Then also people, for me it's important, it is I mean, for those of you that's not yet valuers, I want it to be practical as well, so you must know how to interpret your Surveyor General diagram. Make sure I've given you one or two. The Surveyor General's website is there. It's not a very user-friendly website, but you know, go and find and get your own SG diagrams or so, and see, according to the questions I have asked you previously, if you are able to identify the different kinds of information. Also have a look at your title deeds, people. You've perhaps got a title deed or two for Mr. Kalima in market valuations. Go again, and this time read through that title deed, you know, and not just sort of picking out all the information that he wanted. Read through it from a sort of a legal perspective, and see the kind of information that you can pick up from that title deed that you would be needing for your valuation.
Sectional titles.
Sectional titles, again, very important. People there, know your definitions. I want to see that you know what is the difference between a unit and a section. Nee, it still really irritates me. My colleagues, I've been working for 15 years as valuers, and they still mix it up. It irritates me. Nee, people, there's a reason why certain things have got certain names. Nee. So, yeah, so make sure you know what is a unit, what is a section. Nee. And yeah, also, as I said, the definitions there. Know what is common area, what is participation quota, what is exclusive use areas. Nee, that is all the terminology that you will be confronted with when you do the valuation of a sectional title unit. Nee, and then you need to know what you are looking out for, or what forms part of what. Okay, so yeah, that's very important. The rest is pretty much real security. There's not a lot in there. I don't say there's nothing in there, but I think for some reason I sort of skipped real security. And also people, I've said it before, partnerships and that. Nee, I can't remember what's the name of the chapter. We'll have a look now.
It's 5 or 6.
Yeah.
Commercial associations.
Yeah, commercial associations. Nee, yeah. That's also not in the paper. Nee, by now, hopefully you know what is a contract, what's a company, and so forth. So I'm not going to test you on that. So yes, I would say all the sort of more practical stuff, everyday stuff. Nee, chapter 1, also important that you know what is real rights, what is limited real rights. Again, just around the terminology. Nee, that if you hear it, you know what it means. Okay. But yeah, then lease agreements also only about, say, 10 marks. Nee, most people, the bulk of the paper will come from the law of contracts. Okay, law of contracts, servitudes, and sectional titles, I would say. And the rest will be just more filler questions. Okay.
Will it be a 130?
About 125 marks in 2 hours' time. But as I said, except for the shorter 5-mark essay questions, most will be 1A, 2C, and things like that. Yeah, so obviously you need time to read it, but I mean there's not going to be a lot of writing to do. Yeah, so 2 hours should. I'm still after how many years? I still can't time myself. So I've got, but yeah, I'm sure that you would rather you would be left with quite a lot of time. So yeah.
Usually with his. Well,
yeah, usually
as little as me.
there's time left, but yeah, no, you should be able to finish comfortably with this. Okay, so it's definitely 2 hours and round about 120-25 marks. Okay, people, so let's start with the law of contracts. Yeah, we've touched on it a little bit with regards to our lease agreements. When we did that, sort of the basis of property valuation, and we've spoken about that, how your lease agreements influences value, because attached to those lease agreements, and usually the length of the lease, and also who you have that lease agreement with. Say for instance a company with a good covenant, like say Woolworths, Pick n Pay, ShopRite, hopefully still our government, that you will know over the next 5 or 10 years you will get your rental on time every month. Okay, so that is what we are buying. We're buying that cash flow. And we've done some government departments evaluations of their portfolios where they feel it is fine as long as we get our rental. There were lots and lots of buildings with no lease agreements. People from a valuer and from a property specialist side, that is just not on. You are robbing that portfolio of millions of rands, because of the value that is taken off. Because why? We will up the cap rate in those properties, because the risk is higher. That tenant can decide in 30 days time, you know what, we are out of here. And you might struggle a year or two to fill that building again. So I really cannot stress enough the importance of a lease agreement. So today we are going to look and see a lease agreement is obviously a contract between two or more people where they have certain intentions, they have certain legal consequences that they want to come into play. Obviously, they must have a specific juristic capacity that they can understand the consequences of the acts, and that is why they can conclude a contract. Also, we must be very clear in the acceptance of this obligation, this legal obligation between the two parties, and we must be clear also what we want to happen between the two parties. It mustn't be ambiguous or perhaps just sort of muddled, and it's not really clear what we are trying to achieve with this contract. People, so with regards to this, that first paragraph, and that second one, have a look at those two paragraphs. That tells you literally everything about the rest of the chapter. Also, I have given you, I think I have this sort of basic, look here, this sort of basic law of contract basics. This is sort of just like the skeleton. So you can perhaps read through this, or perhaps study first through, or you decide, But then this is now just to sort of giving you the main points of the whole 25 pages, and then you can just fill that in and so on, just to sort of give you a little bit of a perspective of where we are trying to go. Okay. So. So here we are talking about it's a legal relationship between two or more people, and they want certain legal consequences to flow out of this agreement. They are both they both have the capacity to enter into contracts because they can understand the consequences of their actions. So in other words, I promise that I will pay you 10,000 Rand, and you take on the obligation that you will, say, service my car or spray paint it in funky colors or whatever. So there's this bilateral agreement between the two parties. Okay, so there it is, the essentials or the requirements of a valid contract. Both parties must make their intentions known to the other one. There is no purpose if I want you to do something for me, but I don't communicate with you. How must the other party know that that you actually want to buy something from him if you don't communicate? There we said it must be within your contractual capacity. People, and the only reason, we'll talk about it in detail later, but the reason for that contractual capacity is not to punish anybody, but actually to protect them. So the law is trying to protect people that cannot foresee the consequences of their actions. Okay, obviously people, performance must be possible. If performance is impossible right from the start, I'm selling my horse right now, meanwhile it has died this morning, I just don't know it. Then performance will be impossible right from the start, and it will be as if there was never any contract. Okay. So that contract will then be void. The agreement has to be lawful, obviously. We look at that as well, but you cannot go to the courts and say, you know what, I bought uncut diamonds from this guy, he took the money, but I'm still waiting for the diamonds. Something like that. It must be lawful if you want the protection of the courts. Okay. Then both parties, people, must have serious intention that we want a legal obligation to be established between the two of us, and we want to see the consequences through. Okay, it mustn't be a wishful thing. There must be the serious intent for stuff to happen. The performances must be definite. In other words, again, both parties must be very clear on what is what they are supposed to do. What is their sort of input into the contract. And the last and the most important one is there must be consensus between the two parties. Nee. Consensus sort of meaning a meeting of minds. Nee. Both parties must think exactly the same and have the same expectations from each other for the contract to be valid. Nee. So I mean people, this will jump out of you. Nee. Very nice questions in the end exam, because this is where everything starts. If the one party can show, but you know what, this agreement is unlawful, nee, then there won't be a contract. Nee, you cannot go to the courts and say we had this agreement. Nee, because one of the legs on which this whole contract stands is not there. Nee. And consensus is probably the most important one, and we're going to talk about consensus in detail in a little while. People, then we just back with regards to lease agreements, those three terms of a contract that we can divide it into. The first one is the essentialia of a contract. Now people, if you are selling something, obviously in that deed of sale there must be something that you are selling. I will sell my house to you for 500,000 rand. That is the essentials part of the contract, or the essentialia. Then the second type of the second form in a contract would be our naturalia. People, that is anything that flows sort of automatically out of a specific type of contract. With lease agreements, we said the question of subletting that premises. Subletting of premises will always automatically be in a lease agreement, and it will state that the landlord will not withhold his consent unreasonably. Okay. Only if the party specifically wants it to not be so, they will then change it or take it out. And we said obviously there's goodwill that you will bring that to the attention of the other party, where you will be saying, I'm scratching this out, please initial for me against that paragraph, because I'm taking it out. I don't want this natural sort of automatic clause to be in our lease agreement. Okay, for something that you are buying, perhaps there is a clause that says there's a 12-month guarantee. So again, you will inform the buyer that, listen, we are not guaranteeing this fridge, for whatever reason. And it will be scratched out of the contract, and both parties will initial to, in that way, show the then whatever, if there's a problem later on, we have both signed there, we were both aware that this standard clause was taken out of the contract. Okay, then our third one is the incidentalia of a contract. The third part, people, and that is anything that one or both of the parties are putting extra into the contract. In other words, I'm saying, I want to buy your car, I want to buy it for, you say, okay, I want 500,000 for it, and we will have our incidentalia where we say, can you have the car delivered to me on Friday at 4 o'clock at my house. So that will be something additionally that is brought into the contract. And obviously that is part of the contract. Say for instance a wedding dress that needs to be delivered by a certain time. If it's late, I mean, you don't want it. Yeah, major problems, you definitely don't want it that Sunday or something like that. So you can see sometimes this incidentalia that we are bringing extra into the contract is there for a purpose, and that is part of the conditions that is written into the contract. Okay. Then people, consensus. Consensus, animus they call it in Latin. It's a meeting of minds. Both parties are thinking exactly the same about what we are trying to achieve with this contract. So the parties must be aware of their agreement. They must know about it. It must be unanimous. with regards to the consequences flowing out of this contract. No, they must exactly know this is what I'm going to pay and this is what you are going to deliver to me. No, there must be no ambiguity there. Okay, and then lastly, obviously, we want to create a certain legal tie, a legal consequence, a legal link between the two parties. Okay, so we are all of the same mind. This is what we want to make happen with the signing of this contract. Okay. Good. So this requirement for a valid contract, you know, with regards to auctions, people. I went to an auction. Actually, well, I've been to several auctions, but this is sort of the first auction that was now really specifically property related, and I mean where they were literally selling about 50 houses or so, within a question of an hour or two. You know, usually that this specific auction house has hit about once a month, you know, at a hotel. And we thought we'll go, you know, as property valuers, because usually the auctioneers don't realize the value that that information has for property valuers, you know. So we thought if we can now get the catalog, you know, we'll get a lot of information and then we can use that sales later on. But there, what happens is you must register for the sale. I think also so that people don't just bid and then they, you know, get cold feet 20 minutes later and they just sort of run away or whatever, you know. So you have to register. I think sometimes you need to pay a refundable deposit and you will get a little paddle, you know, with a number on it. Nee. So that sort of lifting up that paddle, nee, and showing it to the auctioneer is then your way of telling him, I am in agreement with the 500,000 that you have just quoted. Nee. So you needn't always talk to somebody or communicate something verbally for a valid contract to come into being. Nee. So there's conditions that you need to read before or when you sign on that dotted line into the register, and you are then supposed to comply. Nee. Say 5% of the sales price will be the commission that will be added on afterwards, you know, so that you cannot say afterwards, I did not know. Nee. When you sign in that register, you acknowledge that you have read the terms and conditions. Okay. So I must say I also sort of bid there on something, but yeah, it's quite scary. That legal consequence, you know, that's going to be hammered. And then afterwards you think, I should have gone higher, you know, but at some stage you, get a little bit of cold feet. But yeah, and also you must remember, people, that something like land, nee, land cannot be sold verbally. Nee, you must have a written deed of sale if you want to sell land. Nee. But I mean, I can also sort of, we can also have a contract where I then say acceptance of the contract must be written. Nee. So I can specify how I want you to acknowledge that there is an agreement between the two parties. Okay. So you have to comply with that in order for that to be valid. Okay. Good. Then, people, with regards to an offer is an intention from the one party, a contracting party, nee, to another party where he wants that party to enter into a specific matter with him, and it will also have a specific effect, nee, that comes into being. People, so you must also distinguish, nee, that a retail shop that puts a dress, say for instance, in the window at a certain price, nee, that is not necessarily an offer to make a contract, that is more an offer to do business. Nee. So if they make a mistake, nee, somebody puts the decimal in the wrong place, you know, now the dress is only 29 rand, then the store can come back and say, no, it was a mistake, it's 2.99 or something like that. Nee. So you cannot now say, no, 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 but I took you up on your offer, so there was now a valid contract between the two of us. So the law said no, or it was also test, believe it or not, about a pound of tobacco that a man said the shop, which offered it at a very good price, there was a contract between, and they took it to court, you know, so he obviously felt very strongly about that tobacco. But the court said, no, 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 this was just an offer from the shop to do business with us. It was not an offer that we have a contract between the two of us. Okay. So yeah, the requirements for a valid offer is obviously the offer must be complete. No. So in this offer you will say, I will pay you 25,000 rand if you build me a house and this and this, and the specification. I recently met a man, he is busy building a house by sort of, you know, these plot and plan developers. And now that the house is sort of past foundation stage and the walls is going up, you know, he was saying, but this doesn't look like the house that I sort of saw on my plans. And believe it or not, people, he paid 50,000 rand extra for the architects to even give him a 3D. I thought that was like for free. To give him like a 3D presentation of the house. You know, so I would think he has quite a good idea of, you know, what the house is looking like. But no, yeah, they started, what do you know, now the walls is going up and suddenly stuff is now looking strange. So then he went to the contractor and he said, listen, I want to see the plans that I have signed off as part of the offer to purchase, because this isn't looking right. And he cannot get that plans out of the developer. Now, when I was now reading through this, I thought, you know, I'm not an attorney, so I sort of, you know, I will give a word here and there, but I mean, yeah, I don't see myself as legal advice, but I mean, surely if we just look at that from this class notes, that signed building plans is part of that contract. Remember how we said that just because that one annexure wasn't annexed to the lease agreement that showed when the shopping centre is the shop, the court said there's no contract into being. How much more so with regards to a house that's being built for you? Say for instance a house of 2 million rand. How can you just say, I will build you a house for 2 million rand and I say yes? Can you see, I mean, what does a house of 2 million rand entail? Huh? What about quality? No. How many bedrooms? I mean, the list is just limitless. So to me, as far as I understand it, I mean, as far as I'm concerned, there's no contract between the two of them. No. So I said, you know, going backwards or forwards, both are equally terrifying. No, because you've got a house half built, you've already, the bank has made 2 payments to the contractor, the land is already registered on your name. You know, you sort of want them to go ahead, but you are getting a product that you never wanted. You don't want this. So yeah, it's I don't actually know how you can get out of that without it costing you a lot of money, you know. But yeah, so you can see people, it must be very clear. So that you're going to also understand that there's no consensus, there has not been no consensus between the two parties. No. Yes, I said I'll build you a house, I said I'll pay 2 million for it, but the detail, there was never consensus about that detail, ever. Yeah, so, problems. Yeah, so there it is, the offer must also include all essentials. No, we've spoken about this, and of this particular category of contract, sales contract, a lease agreement, how many years, which unit in my block of flats, what rental, what escalation rate, and so forth. There it is. The offer must be clear and unambiguous. It may not be vague. No, so what they literally have there is, build me a house on Earth 123 table view for 2 million rand. No, completely vague. Okay, there it is. No contract comes into being owing to vagueness. No. So I mean, now he's now this guy has now said he's not going to pay a cent further. It must now first be sorted out. He needs to see, because I mean, obviously there must be signed building plans because it's been approved by the city because they started building. But now, so I said, I think you better approach the city and they can give you a copy of the building plans, and then you can see if it's your signature or not, you know. But I don't understand why the developer would even do it. What made him do it, or what? Yeah, it's just terrible. But yeah. Okay. Good. Any act which expresses the intention of a person may be regarded as an offer. Okay, so the moment that you are serious about setting certain legal consequences in motion, that is seen as an offer. Okay. There it is. It must be made deliberately with a clear intention that you want to be legally bound if it is accepted by the opposite party. Okay. Good. So from that is that story where something that's advertised in a shop or in the newspapers. It's not. It's only an offer to do business. It is not a contract. Okay. And then obviously the offer will be complete once the other party knows about such an offer. Okay. Then the lapse of an offer, so in other words, how long does this offer stay sort of on the market? Well, obviously our law says for a reasonable time, depending on the circumstances or the type of contract that we are doing. Or obviously you can make it a lot easier for yourself to just say, this offer will lapse Friday afternoon at 5 o'clock, on this date. Say for instance, an offer to purchase a house, and then they will say you have to sign to take up the offer to purchase before this and this date. So obviously they will give you 2-3 days where you sort of not pressurize you now into a decision. You want to take your time and find out, you know what, we're selling for this, what can we get for this, can we get something similar in this area or whatever. Hopefully you've done that by this time. But yeah, people don't like to feel that they are, you know, sort of pressurized. So 2-3 days or until the end of the week at 5 o'clock, otherwise the offer lapse. So if you then come back and say, I'll buy your house for 2 million, then it's then seen as a counter offer, because you haven't responded in time. So that original offer is now lapsed. Okay. So that will make it easier. Otherwise, our courts say within a reasonable time. I would think for you to take up an offer, take a month to take up an offer to purchase, I would think that's definitely not reasonable. I would think perhaps a week or something like that. But yeah, it can make it difficult. Somebody else might think they're still reasonable. Then people, obviously, if there's a death, then obviously there's no consensus between the two parties. However, if death only occurred after he has sort of taken up the offer, then obviously there certain expectations was created that this and this is going to be happening. I am buying the house, now you've died before it's been registered. Then that matter will then now just be taken up by the executor of the deceased estate. So it's not to say that everything now falls flat.
Let's say I want to buy the house and then I pass away. Will my wife still be bound to go ahead with the offer?
Yeah. Or I would think, I don't think people are unreasonable. We'll see about this as well. You know, perhaps if there's agreement between the two parties. The seller then says, you know what, it's fine. We've also decided we don't mind staying another year, you know, and then putting it on the market. You know, so one can always approach and say, you know what, this is now this huge stressful time, you know, to also move, you know, if it won't suit me or something. Yeah. But I mean, if the seller obviously says no, you know, then you have no choice. The executor will then just be going forward with that. Okay. Then obviously we have something like rejection. You say, no, thank you, I'm not interested. Or as we said, you can have a counter offer. Now I'll buy it for a little bit less, say 10,000 less. Then that is a new offer. Okay. And then obviously that counter offer incorporates a rejection. I've now rejected your 50,000, but I will pay you 40,000. Okay. So that's my counter offer. Then we also said that any offer can be withdrawn before the other party knows about it and responds to it. So I can make an offer. Say for instance, I can put my house on the market, and then I hear about something positive that's going to happen in the area. I can't think what, but whatever that might push up the prices or so, and then I just withdraw it. I mean, nobody can hold me to that. Nobody has communicated with me that they want to buy my house, so I just take it off the market. Okay. And then we also get something like irrevocable offers. In other words, I cannot withdraw it. Now, something like that would be more towards an option. And that is usually what your land developers will do. They are interested in a piece of, say, agricultural land, but this land is now bordering on the town. And then they will make an offer to the farmer, and they will usually pay for it. Big money is involved. I've heard of offers of R1 million. That's not refundable. So we will give you R1 million, and you will give us that right. That you will approach us first before you buy, or you give us an option for a year. You will not sell within a year, and that gives the developer a chance to do his homework. To find out what is the demand in this area, for what type of housing is it. Do the feasibility studies, make sure, soil conditions, everything like that. So they are actually buying time. So in that sense, they are saying, and then after a year, they will perhaps approach the farmer and say, listen, we will offer you so many millions, for the land. Okay. Good. People, then acceptance. There it is, acceptance. Yeah, so all that's a little bit, whatever year is, we are still sort of under requirements of a valid contract. So yeah, I think this little thing in it, this basic thing will help you to just sort of get the bigger picture here. Okay. So acceptance is obviously agreement between the two parties. We are both on the same page, the same mind, animus, consensus. So that is why we are accepting the offer. So this acceptance must comply with certain requirements before it becomes valid. Okay, again, it must communicate it to each other. The other party must know about it. It must be unambiguous. It means there must be no uncertainty between the two parties. That is what we are talking about. And this offerer stipulates the mode of acceptance. If he says, I want your acceptance of my offer in writing, you cannot verbally communicate it to him. That is his condition, so you must write back, put it on paper. Also, the acceptance must be unqualified, meaning that you cannot say, no, I'm not giving you 50,000, I'll give you 40,000. Because then that is a rejection of the original offer, and you are bringing him a counter offer. Okay, good. And then again, the acceptance must take place within a reasonable period. Okay, good. Now we are talking contractual capacity. Remember we said between two parties that have contractual capacity, in other words, that they can understand the consequences of their actions. Okay. And we said it is more a protective measure from the side of the law than punishment. Okay, good. We will just finish contractual capacity, and then we will take a quick break. Okay. Good. The parties, both parties must have the necessary contractual capacity. The law breaks that contractual capacity up into sort of three categories. The first one, they say people with no contractual capacity. The second one is people with a limited contractual capacity, and lastly, hopefully people like us with full contractual capacity. In other words, we can wheel and deal in the marketplace unlimited. Okay, so completely incapable people, that would be small children. Children since birth up to 7 years. Okay, after that 7 to 14, 7 to, what is it? Is it 14 years? Limited contractual capacity, and then obviously, well, after that, grown-ups. But we can also see completely incapable of contracting, that that children under 7 is also people that is mentally insane, or incapable of understanding the consequences of their actions. They're people with limited mental capacity. Under that is also people under the influence of alcohol or drugs. Again, they cannot foresee the consequences of their actions. So that they have that limited capacity. Okay. Good. Well, here it says limited capacity to contract is minors above the age of 7. Yeah, above the age of 7. Also, people married in community of property. Okay. Prodigals. Prodigals are people that are going about recklessly with their assets or their money. Okay. We'll talk about it now in a little bit more detail, and also insolvent persons. They are all limited capacity. Okay.
So if you are like blacklisted because of your credit record,
I would see
limited.
Yeah, I would also see that as limited. Yeah. Okay. Then, okay, so let's have a look here. Restrictions placed. Well, yeah, there it says on contractual capacity are not considered to be punitive, in other words, to be of punishment, but rather as a protective measure. The reason being that you, as a child of say 12, signs a contract, but you cannot foresee that this is going to be the legal consequences of whatever you have signed for. Okay, so insane persons. This is now people totally incapable. A curator will be appointed for them, and that curator will make all the decisions regarding this insane person. Okay. They cannot even, insane person cannot even do a contract where they only obtain rights, but no obligations. The law says no legal capacity there. Okay. So the curator will then on their behalf sign any contracts for them. Drunkenness, again, intoxication, again, drugs, no idea of legal consequences here. So in that state you cannot even accept a donation, because you cannot make any legal decisions.
But it's only for the period that
you're... No, it's only for that period.
So you'll have to prove that you were...
Yeah, intoxicated beyond or whatever. Okay. Yeah. Okay, prodigals people, that is people that lacks good judgment. They are wasting their money, and in such a way that it's actually becoming so worrying to their family. That they are saying, what, if he goes on like this, we'll be out on the streets in next to nothing. So you cannot just decide this, you will have to get a court order. And the person himself can also approach the court, or his family can. And then there will be a court order, and a curator will then also be appointed for this person. Because of his irresponsible behavior. So he may not he is then regarded as unfit to go into any legal business. Then some legal persons, say for instance like a tennis club, they can perform certain legal acts. We can sign to rent the little club next door or whatever the situation is. Obviously, the legal person in this instance cannot obviously make any personal legal obligations like enter into an engagement to be married. Okay. Then insolvent persons as well, there obviously when they are declared insolvent or they are sequestrated, they become sort of under the protection of the master of the High Court, and the master will appoint a trustee again, which will oversee his business. Okay. And any assets accruing into the insolvent person after he was declared insolvent also then forms part of his insolvent estate. Okay, so there will then be a trustee. Okay. Then convicted persons, convicted of certain serious crimes, suffer certain disabilities of contractual capacity. So for instance, a person who has been guilty of fraud. I'm sure you all saw the newspapers about the student with a 14 million rand. So I mean, and really in this day and age with social media, and I mean, she was studying accounting as well, you know. So here, I just thought, you know, she just way limited her future, you know, because I mean, she's in a position of trust and so forth. So also, yeah, I quickly Googled it as well, and you cannot be a member of parliament as well, if you have been convicted, and I think they say it must be for 12 months and longer, so I don't know if it's shorter than, it looks like a loophole there, If it's shorter than 12 months, perhaps you can still scrape through, but yeah, okay. Yeah, so that person with guilty of fraud may not become or remain a director of a company without permission. Again, people, it's positions of trust. So that is the rationale behind this this law. Okay, then minors. For minors, there's usually a guardian appointed. Children under 7 has got no contractual capacity. Okay, then between 7 and 21 years, they have limited contractual capacity. People, and really, I read the other day an article about social media and cyberbullying and things like that, and I really think that the children is, the article was actually about 2 women who wrote a book about it, because she said it's like drugs, you know. When I was younger, you know, every year or every quarter, you know, there would somebody come and talk to us about drugs. And she said, this is now the same situation that we had with drugs, is that this is it's exploding exponentially, and the children at the center of it do not realize the legal consequences of the actions, you know, and how far it goes and so forth. And this book is sort of trying, you know, to educate parents and children around that. And they even developed, or not they, but there is actually a little app on the web that you now can perhaps buy your children, where they can actually sort of hold that message back so that you can reconsider it in, say, an hour or so. Are you still sure you want to send it? And I thought, well, that is already quite wonderful, you know. And yeah, so what, or teenagers think I'm still a child and I've got no legal, there's no legal, or they don't even think of the legal consequences. But yes, you know, they are now in that phase where they have this limited contractual capacity, so they can actually be responsible for their deeds. Okay. Good. Okay, then married women, people, there we're talking about the joint estate. So if you are married in community of property, then obviously you cannot have certain obligations onto your partner that he knows nothing about. So obviously he will have to co-sign if you are going to buy something.
But the same with the man.
Yeah.
Or why does it say married?
women. Yeah, there it says, yeah, that is, I think that's a bit ambiguous there, because it says there the abolition of the husband's marital power in 1993 makes it no longer necessary to consider the former restriction on a married woman's contractual capacity. Yeah. Even if married in community property, a married woman and her husband now have the same powers and obligations as each other in connection with their joint estate. Yeah. Yeah, I think it's probably perhaps just a lingering perception still, you know, yeah. But yeah, the legal thing here is married in community of property. No? So we are joint owners of an undivided share of this common property or this estate. Yeah, okay. Good, and there it is. I think, I think let's take 5 minutes. No? 5-minute break, then we'll come back to the performance must be possible.